already concluding our third annual Thiel Forum series, which I cannot believe, but today concludes our third annual forum. And today we have a wonderful variety of presenters, both faculty and students. And it's this combination of faculty and students that I'm convinced is what makes our Thiel Forum so enjoyable and successful. Our first presenter is Professor Matthew Mangino, a lawyer in his own right, who is also an adjunct in our political science department. He will discuss the death penalty, executions, and the anguish of victims from the perspective of a book with which he's familiar, titled The Executioner's Toll 2010, a look at 46 executions in a single year. He will discuss how the book provides some compelling stories, accounts often neglected in this mainstream media. I'm happy to present a scholar in the field of the death penalty and political science, Professor Mangino.
It's a pleasure to be here. Again, I'm Matthew Mangino, and I'm an adjunct in the political science department. And I'm here to talk to you today about the death penalty and a book that I had written on the death penalty. It was published last spring by McFarland and Company. And when I thought about how I could talk about the death penalty in 8 to 10 minutes, I thought that I would talk about the death penalty by the numbers. And the first number is number 46. 46 is the number of inmates who were executed in 2010. And it was the framework for my book, The Executioner's Toll 2010. The book took a look at every execution that occurred in that year. There were 46. So we looked at every execution from January 1st to December 31st. And it was an interesting year for the death penalty. In fact, there was a woman executed in 2010, one of only 15 executed in 35 years. There was an execution by electric chair. There was an execution by firing squad, which was extremely unusual. So what I did is I took a look at each of those cases, from the crime to the trial to the appeals, right up to the last meal in the final statement. And they're tragic stories. Every one of them begins with a murder and ends with an execution. But the reason I looked at these 46 executions in a single year was because typically people who write about the death penalty write about it from a certain bias. They're either for the death penalty or against the death penalty. So I thought one way of looking at it in an unbiased fashion would be to look at every case in a single year. And so those cases would include those that were rallying points for death penalty abolitionists, and maybe were cases that cried out for the death penalty. But they would all be looked at in an unbiased fashion. The reader could make their own decision after reading my book. The next number that I want to share with you is 12,065. That's the number of executions that occurred between the administrations of Andrew Jackson and Richard Nixon. Actually, the years are 1834 to 1970. And why is 1834 important? Well, in 1834, Pennsylvania decided that public executions were a spectacle. And they were the first state to move executions behind the prison wall. Why is that important? Well, it was because it was the first time that a state entity acknowledged that the death penalty is different than other types of punishment. And that they were almost embarrassed that they were carrying out these executions in a public way. After that, and Michigan became the first state to abolish the death penalty in 1846. States began to look for alternatives to the death penalty, to methods of execution. The electric chair was introduced in 1888. Why is 1970 important? 1970 is important because there were no executions in 1970. Zero. And there had been a decline in executions throughout the 60s and obviously into the 70s. So practitioners, lawyers, people in the criminal justice system knew something was going to happen. And that's the next number that I want to share with you, and that's 1972. In 1972, the United States Supreme Court decided Furman versus Georgia. And what the Supreme Court said in 1972 was that the death penalty was arbitrary in the way that it was imposed. In fact, the court said that it was freakishly random. Justice Potter Stewart, who wrote the opinion in Furman, said that the death penalty was cruel and unusual in the same way being struck by lightning is cruel and unusual. So the death penalty was gone. Everybody who was on death row had their sentences commuted to life in prison, and we were done with it. Sort of. Because what the Supreme Court didn't say was that what the Supreme Court didn't say was that the death penalty was cruel and unusual and a violation of the Eighth Amendment. They only said it was arbitrary and was unconstitutional for that purpose. So states went back, started working on their death penalty statutes, and the death penalty was reintroduced. And the cases made their way up to the Supreme Court in a case, Gregg versus Georgia. And in Gregg versus Georgia, states proposed a new way to carry out the death penalty, or to impose the death penalty. And what they did was they bifurcated the trial, which means there would first be a guilt phase in a death penalty trial. The part of trials that we know about, where you prove beyond a reasonable doubt that a person is guilty of first-degree murder, planned, premeditated murder. Once that's done, now the cases move into what's called the penalty phase. And in the penalty phase, the state has to prove certain aggravating factors. And those aggravating factors was what was supposed to split the death penalty from other types of penalty, because it would only be applied to the worst of the worst. And those are people who maybe murdered a child, or killed a police officer, or committed a murder while in the commission of another felony, or carried a murder out through torture, or killed a pregnant woman. There are about 18 factors in Pennsylvania that can be used as aggravating factors. Also, the state said that you could present mitigating evidence, that the defense could present evidence that said, my client has mental health issues, or drug abuse issues, substance abuse, or that maybe they were abused as a child, or they had a lack of education. And what it came down to is that those aggravating circumstances outweighed the mitigating circumstances. You had to sentence that individual to death. So the death penalty was back. In fact, 37 states rewrote their death penalty statute so that we could again have a death penalty in the United States. The next number that I want to share with you is 18. And why 18 is important is that is the case in 2005, Roper versus Simmons. And in Roper versus Simmons, what the court said is that it's no longer constitutional to execute a juvenile. All right, anybody under the age of 18 cannot be subject to the death penalty. What's interesting about that is only 15, 16 years earlier, in 1989, they said that 16 and 17-year-olds could be executed. They changed their mind because 30 states had banned the death penalty for juveniles by 2005. And what they said that was a national consensus. And because of that national consensus, it gave evidence of an evolving sense of decency. And therefore, the Supreme Court did an about-face on juveniles. They also did an about-face on the intellectually disabled. Because in 1989, they said that you could execute someone who's intellectually disabled, and they changed their mind in 2002. So the Supreme Court began to whittle away at the death penalty, make it more narrow. The other numbers I want to share with you are 3 and 13. And why 3 and 13 are important is because it gives us an idea of how, in a lot of ways, the death penalty has become a political prop of sorts. Tom Wolfe, Governor Tom Wolfe, he was elected last fall. He had said while he campaigned that he was opposed to the death penalty and that he would declare a moratorium. And when he was sworn into office, one of the first things he did was declare a moratorium. He really didn't have the authority to declare a moratorium, but what he is able to do is stay every death sentence that's scheduled for execution. And he's done that, okay? And the reason he said is he thinks the death penalty is erroneously imposed. And there was furor. Prosecutors across the state were outraged. And I'm a former prosecutor. I understand what their concern was. In fact, the district attorney of Philadelphia sued Governor Wolfe over this issue. And in this case, is going to go before the Pennsylvania Supreme Court. But my question is, why the outrage? There have only been 3 executions in Pennsylvania in the last 35 years. And all 3 of those individuals volunteered to be executed. They gave up their appeal rights, and they asked to be executed. We haven't involuntarily executed anybody in Pennsylvania since 1962. So the furor, the gnashing of the teeth, the pounding fist, is a bit disingenuous. The other number represents Jerry Brown. Governor Jerry Brown of California presides over the largest death row in the country. More than 700 people are on death row in California, almost 25% of all death row inmates. And in the last 35 years there, they've only executed 13 people. And in fact, they haven't executed anybody since 2006 in California. But what Jerry Brown did was last year he spent $700,000 on revamping the death chamber, even though they haven't executed anybody in 9 years. And just in the last month, he's committed $3.2 million to expanding death row, so they can put more people on death row who they have no intention of ever executing. So it just gives you an idea, the competing interests with regard to the death penalty. The last numbers I want to share with you are 35 and 3,000. 35 is the number of people who were executed last year in the United States. Okay? 3,000 is the number of people who were on death row. So the question presents itself, are executions now arbitrary? Just like in 1972 when the Supreme Court said that imposing the death penalty was arbitrary, now are we in a position where executing or carrying out executions, have they become arbitrary? I mean, if you're one of those people, one of those 3,000 people who's scheduled for execution, is that not freakishly random? Is that not like being struck by lightning? That you would be one of those 3,000 people selected for execution? And so that's the question. And what I'd like to do is I'd like to hear from all of you. I have a blog, which is at mattmangino.com. And I've chronicled every execution in the United States since 2010. And what I'd like to do is I've posted on the blog, what do you think? And I'd like to hear from you. If you'd go on and comment, maybe we can have a dialogue about the death penalty. I'd like very much to do that. I appreciate you all listening to me, and I'd be happy to answer any questions that anyone has as well. All right. Thank you very much.
Oh, I was just wondering if anybody's approaching this from the angle of having the death sentence but not executing the death sentence. Is that not a type of cruel and unusual punishment itself, keeping these people on death row for such long periods of time? I mean, I'm reminded of the short story by John Paul Sartre's The Wall, where it explores, essentially the dead man walking type phenomenon that's dehumanizing in many respects, it seems.
Yeah, it's an interesting question. And, one thing that I can tell you is that the forms of execution have never been determined to be unconstitutional. So whether it was hanging, the electric chair, the gas chamber, lethal injection, none of those forms have been determined to be unconstitutional. And as far as I know, there's never been any litigation that has reached the Supreme Court as to whether or not life in prison under the idea of the death penalty is cruel and unusual punishment. I think what's ripe for the Supreme Court right now, which could segue into these, because we see a lot of these cases are just small steps toward a larger question, is the issue of solitary confinement. Because death row is a lot like solitary confinement. You don't mix with the general population. You only have a couple hours of the day out in the yard and able to mix with other people. So it's almost like having a sentence of isolation until your execution date comes. So that issue, solitary confinement, is ripe for the Supreme Court to hear, and I think that life pending a death sentence will spin off of that question. Yes?
This is a relatively basic question. I was wondering, is there a difference in upkeep costs, honestly, between prisoners in death row as compared to regular prisons?
Yeah, there is. There's an issue because they're segregated from the rest of the population. They have more intense scrutiny because, as you could imagine, suicide rate is higher in death row and things like that. So there's more scrutiny, in that regard. A lot of people talk about the cost of the death penalty. And the cost is not really related to housing and segregation. It's related to appeals. These matters are constantly reviewed, and so there's a greater expense there. But that doesn't give any deference to the fact that people who just get a life in prison sentence, not the death penalty, just life in prison, they file a lot of appeals too, because they're destined to stay there for the rest of their life, so they're working the courts as well. So the costs, I think a lot more is made out of the costs than is really an issue in terms of the death penalty.
Okay, thank you.
I have a question.
Yes.
As a country comparable to which country also has this high death
Well, they're not many.
compared to the United States?
Yeah, there are not many Western countries that have the death penalty at all. Europe does not exercise the death penalty. Japan is a country that we could compare ourselves to that does, in fact, have the death penalty. But unfortunately, most of the countries that do, we don't normally like to align ourselves with necessarily. And that's, Iran and Iraq and China that continue to utilize the death penalty. So the United States is an outlier here in terms of international use of the death penalty.
And then my second question, what will be the cost of recycling these people into society compared to the cost of maintaining them to the death penalty?
Well, yeah, there's no question. If we could, if we could rehabilitate people and we could put them back into the community safely, it's not only an issue of the death penalty. There are only 3,000 people, and I say that, there are only 3,000. But there are thousands and thousands of people who are serving life sentences without the possibility of parole. And I think the Supreme Court has begun to look at that issue, primarily with regard to juveniles. So there are two recent Supreme Court decisions that did away with the life without parole for juveniles. One was for non-homicide offenses, and the other one was mandatory life in prison without the possibility of parole. So I think the courts are beginning to think about these issues. Do we throw people away, put them in court in prison for life? But that's a good question.
Just a clarifying question on the juvenile issue. Is it strictly anyone under 18, or are under 18-year-olds who are tried as adults? Is there a sentencing that allows them to, if they're tried as adults, to?
No.
So they have to be over 18 in order to be eligible. Let's put it that way. It's a horrible way to put it.
Yeah.
I realize I'm not being articulate, but to have that as a sentencing option.
You cannot execute anybody who committed a crime under the age of 18 for that crime. So in order to be eligible for the death penalty, you have to have been an adult killer at the time you committed the crime.
And can you speak a little bit about what you believe caused the change of heart in the Supreme Court on that issue?
Well, what the Supreme Court said was that it was these evolving standards of decency. Because 30 states had outlawed the death penalty for juveniles, and the fact that those state legislators represented the beliefs of the people in their states, that was evidence of evolving standards of decency. But one last thing that's extremely important in that case, Roper versus Simmons, is that the Supreme Court went beyond that and talked about brain development and said that juveniles are not the same as adults, and that your brain's not fully developed until you're into your 20s, and therefore juveniles are different than adults and should be treated differently. And that issue has now seeped into other areas of the criminal justice system with regard to life without parole and in regard to other serious offenses. So that's why Roper versus Simmons, I believe, is the most important Supreme Court decision with regard to the death penalty in the last 25 years.
But based on that, the fact that they're using, and I looked at my colleague in neuroscience using some interesting neuroscience data on that, why not change the age of adulthood to 25?
Well, there's certainly the issue with regard to that has made age a significant mitigating factor in criminal activity that occurs as adults. So if you're a 20-year-old and you're accused of aggravated assault or convicted of a serious crime like that, age is now a mitigating factor for purposes of sentencing. So I don't know that I think you need a bright line. I don't know what that bright line is. I'm not certainly a neuroscientist, but you know, it's seeping over the line in terms of mitigation on that issue.
Great, thank you.
Thank you.